is that I have been working in the area of ADR along with my colleague, Professor Prasad.
Yeah.
I think. And I did my LLM in labor law. I was a junior to you in the college. So from that time, we were each other. We were colleagues once upon a time.
Yes.
We worked together in one same institution. And now I think our acquaintance goes back to almost like 28, 29 years.
Perfect. Perfect.
And what about you, Mallikarjun?
Yeah. When you recall 28 years of acquaintance and introduce yourself and rope me in that journey.
Yeah.
Half the introduction of mine is over, I believe. And then, of course, as you know, I'm a BA graduate from Gulbarga University. It was a passion to be the teacher, thus went on to do B.Ed. Thereafter, did my LLB, and my journey of LLM from Karnataka University shaped me well, gave me some edge over the subject, and gave me courage to be the law teacher. And fortunately, almost 25 plus years of law teaching. Though not desired, some of the opportunity to lead the institution came in my life at a very early stage. Thus, for over 20 years, I am at KLE Society's Law College, Bangalore, as the principal. And of course, before that, at Belad Law College, we were colleagues as law teachers.
Just for the benefit of the viewers, Belad Law College is in Belgaum, Karnataka State.
Correct. And belongs to KLE, as KLE has 7 law colleges today. Thereafter, for a very short stint of time, I worked at Bagalkot, Basaveshwara Law College. And for over 25 years, I am here. And I'm happy that with the support of all my colleagues from day one, I took interest in organizing these kinds of events, which will bring benefit to all stakeholders, especially the students. The tremendous exposure the students get in honing their skills, be it advocacy, be it communication, largely drafting, exposure to places, people, subject, and so on. Thus, my interest and my colleagues' support made me organize almost 3 to 4 such events annually. Conferences, national moot courts, client counseling, trial advocacy, negotiation competition, and now this unique competition.
Okay, you are anyway into thanking mode. Let us continue that. I think without remembering and appreciating the institutions involved in the events.
The present event.
This conciliation event.
Understood.
I don't think we should proceed with this.
Yeah.
Can you just put light on those?
Sure. I love doing that. When our good friend Professor Sairam Bhatt gave me a call and tell me, look, here is an opportunity coming from the Department of Justice, Government of India, that some competition in labor law to be done, and especially labor law conciliation competition, as we share the passion for the subject. And of course, for that, teachers are responsible. Immediately, I liked the idea, and I told him, since it is labor law and conciliation competition, we must do it. And he also believed in our meticulous way of organizing events, which he has seen.
Again, for the benefit of viewers, who is Sairam Bhatt?
That's right. I only said a good friend of both of us. I'm sorry for having missed that. A professor for over 25 years, I believe, at only one premier law institute, that is National Law School of India University, Bangalore. And we have a close association, I must say, for over 25 years again. And
I think we have grown too old. Anything we speak at least 30 years old stories. Yeah, we are
young in experience. Yeah, of course.
And he heads CIRA, Center for Environmental Law Education, research and advocacy.
I believe he heads it from day one.
Oh,
Either day one of Saira at National Law School or day one of his life in National Law School. And I do remember and very fondly recall the kind of rigorous and very useful, faculty improvement programs. 21 days faculty improvement programs he was conducting and the keen interest he was taking. Our participation in those events did elicit, and motivate us in taking interest in environmental laws. And when this person came up with this opportunity, I must express my gratitude.
Now you mentioned you received a call from Saira. Then how this idea got conceived? He said just that something on labor law to be done.
Correct.
Department of Justice wants something to be done on labor.
Yes.
So whose idea it is, how it came up?
In fact, it is Sarambat who mentioned that can we do it on labor law conciliation competition. I must tell this. Maybe my student, Mr. Rohit Kamath, and Jai Batra, who is assisting us very closely in hosting this institution. These guys have also played a vital role in imagining this concept.
Jai and
Rohit Kamath, my student.
And they are from this institution?
Yeah, Rohit Kamath is from this institution, my student, who is a very well-performing advocate today. And he has a close connection with National Law School, exhibiting his academic interest too. And that's how all this started.
Jai is from Sira.
Jai is from Sira.
Okay. So that's how things went on.
And as I told you already, I was very happy to do something in labor law.
Yeah, you are LLM in labor law.
Indeed, yes.
And PhD in labor law.
Of course, yeah.
See that clarifies.
Maybe Professor Sarambat too knew it. That I will very happily accept the invitation.
Okay. So now we know the connection between conciliation and you.
Yes.
Okay. So thank you. I think we almost completed first part of our discussion.
Correct.
Let's plunge into the actual reason why we are here.
Correct.
And why our participants, students, and judges are listening to us.
Correct.
So let us talk about the conciliation, how we conceived, and what are the expectations of the people involved in the conciliation process. So when you talk about conciliation, now see, in a room, there are 4 teams. One is a requesting team, one is a responding team, and 2 conciliators belong to different teams.
Correct.
So there are 4 teams and being assessed by the judges.
Correct.
Now, when we talk about this conciliation, I know many people say that mediation and conciliation are similar to one another.
Yes. They find it difficult to draw the distinction
between the two.
Correct.
Is it true?
As concept, I believe it to be so. Yes. As a concept, if you ask me, as a concept, draw the line between the two, I find it difficult. Since these 2 concepts have taken their root into law, and we check the applicable law, then it is possible for us to distinguish between conciliation and mediation.
So how this conciliation is unique than other mediation competitions that happens all over India?
If I'm right, legal framework for mediation came late when compared to the legal framework for conciliation in labor law.
Yeah.
It's in
1947.
Yes.
So from there, the legal framework is there.
Came for conciliation. Conciliation for resolution of industrial disputes.
And in 1940, arbitration legal framework came.
Exactly. Yeah.
Mediation, nothing.
Yeah. I believe mediation story started with amendment to CPC and thereon.
In 2002.
Maybe 1996 Act Arbitration and
Conciliation. Then again, conciliation word
comes in. Correct. Yes.
So therefore, this event, what we have conceived, is exclusively conducted under the control of Industrial Disputes Act 1947.
That is the one very importantly we must convey to our participants.
So therefore, they have to be thorough with the role of conciliator under the act
Yes.
rather than general understanding of the
Exactly.
mediation.
Idea of conciliation under Industrial Disputes Act as compared to the concept of mediation elsewhere. Because we have named it and titled it as Labor Law Conciliation Competition. And that's where a peek into Industrial Disputes Act and getting to know who the conciliation officer, who appoints them, why appoints them, and what happens to the settlement arrived at in the presence of that conciliation officer, who are all bound by that settlement, how long that settlement will have force, and what are the duties.
So that means if they settle something to be implemented for 100 years, 50 years, they have to see whether it is valid under the Industrial Disputes Act.
I have something to suggest there. I think section 19, which speaks about binding, 18 and 19, both of them speak about binding nature and period of operation. Generally, when it comes to period of operation, there is nothing in the act that prohibits you from having 100 years as period of operation. It says 6 months or as agreed by the party.
As agreed by the
But then the contract comes into place. Whether the duration you have agreed is reasonable.
Reasonable.
That has to be looked at.
So that means they have to go through the Industrial Disputes Act
thoroughly. I'll tell you.
Do you think it is the conciliator who should be more worried about the Industrial Disputes Act, or the requesting and responding party also needs to be worried about the act?
About the act, okay. When we say settlement, why the settling party should be worried about the law?
Yeah.
I wish them not to be worried about it, not to be considered. I wish them to be looking at, if I may put it this way, look at what is available than what is desirable.
Yes.
And
look at your interest rather than the rights.
Exactly. That's one way of looking at it. Even if your interest prompts you to have something, whether the other party is ready, willing, and capable to give it, very importantly, capable to give it, then even though it is your interest, as such desirable, you may have to take a step back and look for what is available so that the settlement become possible. And a reality.
Practicable.
Thus, those such things have to be kept in mind.
So you mean to say that I think should we look at this one? Are you suggesting to the evaluators and the judges to see the reasonableness of the settlement?
Yes.
And win-win aspect of the settlement?
Yes, since judges are also given with the CIs, confidential information, they also will be able to understand when your position is so bad or the position of the other party is so bad, your right, your interest, everything is justified, but you see it's not available. Why are you fighting for it? Probably they will be looking at it. I think if parties have not understood, let me further delineate this. If it is an industrial dispute, the price index in the market is such that 20,000 per month is the minimum salary without which you will not survive. Could be one thing. Or little more survival you need. 20,000 is minimum that is required. 25,000 will give you little comfort. There is nothing wrong for workers to ask for little comfort than the mere subsistence. That's right. That's their interest. Not just right. That's their interest too. It's not wrong to have such an interest. But they know very well the financial position of the employer.
They know, nothing is hidden from them.
Nothing is hidden. If that is the case, they are not wrong in fighting for little more than 20,000. But they would be looking for what is desirable than what is available. Is the point I wanted right now.
Okay, let us go step by step. Okay, first thing is when all the teams sit in a room, the first thing is they have to introduce themselves to one another. Otherwise, I think that's the natural first step.
Correct.
But again, here, what I find here is when you talk about introducing yourself, when you talk about opening statements and other things, uh, parties have lived through the dispute.
Yeah.
Is it not?
Yeah. They know each other,
They know each other very well.
though not very well. They know very well, but they don't. Their experience is not very well. That's why they are here. Yeah.
Under those circumstances, how far it is, what should I say, desirable, or don't you think it looks very artificial when they introduce themselves, when they know each other very well?
No, let's not look at it that way. It's not introduction of I to you and you to me. No, it's not that.
Exactly the way we did.
Yes.
We know each other very
Yes,
well, but
yes.
still we introduced ourselves
We did
for the benefit of
weavers. There, these guys would be doing it for the benefit of
conciliators.
Let's understand it. So hence we will have it.
Ah.
There is second reason too, as we were discussing. Probably that could be your follow-up questions. Question 2. Well, let the parties make use of it. In addition to introducing themselves formally, let's introduce their standpoint, let's introduce their emotions, their feeling, their case slowly. To serve that purpose. Why they have come here?
Yeah, facts is also known to each other. So instead of facts, they are going to express their feelings.
Exactly. Yes.
So
when the feelings are expressed, it serves the purpose of conciliator understanding or judges in the competition understanding with what mindset people are in. Who knows? People are in with no mindset to settle, but the other parties have won them and got it settled. Or other party has taken it not sportively, obviously. Whereas the conciliator intervened and subsided, induced them to come to amicable settlement. Then score goes to conciliator. Of course, it should go to negotiator and client too, because they have mobilized.
Then what counsels are going to tell in their introductory part? Because here what happens is parties can express their feelings.
Correct.
Counsels cannot, should not express their feelings because they are professionals. So when they are discharging their professional duty, they have to be hardcore.
Of course, yes.
So therefore, their introduction should not contain anything about facts, because facts is known to everyone in the room.
Correct.
But it should contain something about their opinion about the process.
Yes.
And
willingness to
participation.
And their
expectations from the party. Respect to the process. Expectations from the party.
Exactly. That has to be certainly put by him too.
Yes.
So
counsel's opening statement will be very different.
True.
And conciliator on the other way, because he is the master of the whole process. He's actually in control of the whole.
Correct.
So he's going to express his ground rules to be followed.
Yes.
And also he can appeal to the parties that what is expected.
Yes.
And encourage them to talk freely.
He may not be the guy to enforce, but he is the guy who is part of the game.
He can guide them. What is the best way to go about? How to go about?
Yes.
I think opening statement is a very important stage which should be utilized by all.
Correct.
So once they do with the opening statement, then comes the agenda.
I just wanted to add to, before we go to agenda, participants must understand that all efforts to settle the disputes went futile. Now, of course, it's not the question of mediation or arbitration, it's the question of conciliation. A government-appointed officer has intervened since he is duty-bound to intervene and make an attempt to settle the dispute. So, the parties also must acknowledge his presence. And the conciliator should, in some way, showcase to the parties that, look, I'm a government representative. Though it is your personal matter, industrial progress is important. Industrial unrest is what the state is interested in putting it off.
economic interest of the
economic
state.
interest as a result.
Yeah.
As a result. That's why I'm here representing the state. You must honor my position and you must participate and you must cooperate. Though you may not be dictated by me, you should agree to be guided by me.
I think you brought another major difference between mediation and this event.
Yeah. Mm.
Because the conciliator sitting there
Yeah.
is not anybody.
Yeah. Correct. You're right. You're right. Yes, yes.
He is a representative of the state.
Yes.
And the state is an interested party.
It is. It is.
And its interest in settling the dispute.
Yes. Because it brings back to economy.
Economics. Yeah.
Let's not talk only of economy. Will it not bring back to the welfare of a community? Where will the community go if the essential service or essential goods are not halted? Production of it is halted.
So when the industry survives, the burden on the state reduces.
Yes.
Because industry provides job.
Correct.
Takes
Correct.
care of social welfare.
True. So if you may relate state to the community, if you remember, it's Leo Pope who said, capital employs labor, labor employs capital. Whereas Mahatma Gandhi said, both of them are employed by the community. Securing community's interests is the job of state. Thus, state has a role in resolution of industrial disputes. Hence, I have sent my man conciliation. What happens if you go adamant and do not listen to him? The next stage is, I will come with the weapon of compulsory adjudication.
He's going to give a failure report.
Yeah, he gives a failure report, and thereafter, what I will do is, as a state, I'll send you to labor court. Just go by whatever presiding officer decides, like it or dislike it, and start the industrial progress.
I think it's the best chance to settle the dispute because there's someone who can listen to you.
Yes, ultimately it's your settlement. He will listen to you and he will guide you. As I said, he will not dictate you.
So in this event, before start of the actual conciliation, for 30 minutes, the negotiating parties, that is requesting and responding, are given a CI. That is a confidential information.
Correct.
Which conciliator has no access to.
Yes. Yes.
So conciliator is coming with a clean mind.
Correct. But
the parties are coming with a loaded mind.
Loaded mind, and conciliator as a part of the competition. Conciliator knows that guys have
something in their
mind. So he should make efforts to elicit
it and then try to resolve the dispute.
So should we also tell our participants that if the conciliator does a better job in eliciting the CI, they are supposed to be disclosing. If such disclosure goes against their interest because it is going to be heard by other party, let them take caucus and disclose. Is that
possible? Yes.
Because it is the concerted effort. Conciliator doesn't sit as enemy to any of them.
Yes.
Nor conciliator will see other two parties as enemies.
Taking one step ahead of this, what do you think conciliator should do if one party has come unprepared and it is agreeing for something which is very unpleasant? Should conciliator keep quiet or should he intervene?
Very interesting one. I will go ahead and tell you. He intervenes. He is bound to intervene. He will intervene. But what if parties will say, you please don't intervene?
We are agreeing.
We are agreeing.
And as per the concept, it's the agreement of the parties.
It's the agreement of the parties. It is, after all, the facilitated settlement.
Yes.
By the parties. We call it extended collective bargaining. It's nevertheless collective bargaining only. Extended stage of collective bargaining. It's the settlement of the parties. So typically, either because one party has not come prepared, or he has come prepared and he is vulnerable. His vulnerability compels him. He is not going to listen to you, the conciliator. He is going to listen to his belly and requirements of his family. If he ends up agreeing for the settlement, which on the face of it is unjust, then it's very interesting thing. I don't know whether under the concept of mediation, if the mediator agrees for such settlement, I don't know. Whereas the provisions of Industrial Disputes Act 13, 12, section 12 and 13, I believe,
12
which
subsection 2,
speaks about duties of conciliation.
duties of a conciliation officer.
I wish all conciliators, all team to observe this and make reference to that. These conciliation officers, either individually or as members of the board of conciliation, are charged with the duty of making all efforts that are necessary to promote, mark my words, fair and amicable settlement.
Fair and
Amicable settlement. Natural corollary of that.
amicable is friendly.
Friendly. Fair we
Fair
understand.
is
Fair we understand. I think we understand.
so if a party is unprepared,
Are vulnerable.
vulnerable.
I am prepared, but I am vulnerable.
Shall I suggest an idea?
Yeah.
How to go about it?
Yes.
Or is it against the what should I say? The ethos of the competition? Because if I give an idea, people may adopt it, no?
Let's see. Let's see. Let's do it in.
But anyway, we are giving this idea to everyone.
Everyone. Yes.
If a party is vulnerable,
Ah.
and if the conciliator feels the party is vulnerable, the best way forward is call for a caucus, educate the client, and tell him that vulnerability is possible for other party also. The brave face which the other party is showing,
Yeah.
fake.
Correct.
So you think that you are the only one party with the problem.
Correct.
There may be a problem on the other side, which you are not exploring.
Correct.
So don't you think he has lost his impartiality here? Because he is no more an impartial person on a conciliation.
No, let's not see it that way. He is the protector of, is he not the protector of interests of both the parties?
He needs to be correct.
He is. When he understands that one party is going to suffer, if he goes to the rescue of that party, I don't think he is partial, he is just.
So therefore, concept of impartiality is different in litigation and in EDR.
Indeed, yes.
In litigation, judge will not go in search of evidence so that a vulnerable party wins.
Correct.
He decides lack of evidence, other party wins.
Correct. The
Expert, it didn't come, so other party. Here,
fortunately not adversarial.
Here it cannot do that.
Yes.
He has to protect the interest of both the parties.
Yes. And such a move should not be treated as partial.
Yeah, should not be treated.
I am coming back to your question.
Yeah.
It should be rather treated as just and independent.
Independent.
Yes.
So therefore, it's not impartial, it's omnipartial. So he should be with both the parties.
Yes. Yeah, that's it.
So I'm with you, both. You need help, I'll help you. You need help, I'll help you also.
Correct.
It's not touch me not.
Correct. True.
It's forget me not.
Yes. Forget.
Ask my help anytime.
Correct. I understand.
Okay, so now I think we went.
Correct.
Now we were discussing about agenda formation.
Yes. Yeah. Shall we conclude on this quickly? I just want to add, when we were talking about fair and amicable, let's put it across and say, in our understanding of the provisions we made reference to, if the parties, even though you conducted caucus and informed them, look, you don't know the other party's vulnerability, they also may have vulnerability, struggle little more, and it's not good for you, but they say, I know all that. For me, resuming the work and getting less wages than what I was already getting is also okay. Because I have to run my family. If they say so and the trade union is ready to get a settlement with the employer, if they do not listen to you,
which is exploitative,
should the conciliator be a party to an exploitative settlement? Looking at the provisions we have made reference to, I would say he cannot be a party to such settlement. Let's see how the participants are going to handle this. Anyway, we are only giving the interpretation of that provision.
Provision,
Yeah.
yeah.
Yeah, please go ahead. You are saying something.
Okay, now confidential information is given. Now the purpose of the confidential information is to abridge, shorten, and concise the scope of discussion on that day.
Yeah, correct,
So,
correct.
The conciliation, I think conciliation officer has a 14 days time to settle the dispute.
Yes.
So in the 14 days time, on an average, he may conduct 14 sittings, maybe more than 14 sittings, because multiple sittings in a single day you can pass. So when we give CI, we want to abridge the scope of discussion on that day's negotiation session.
Correct. It's very essential.
It's very essential. So therefore, the agenda what they make should adhere to the CI.
Yes. Yes, yes, yes.
Because I feel that most of the participants must have worked on the general information and prepared an agenda.
Correct. And the challenge comes when CI is given to unlearn all that they have learned and come and relearn. Relearn probably they may do, unlearning becomes difficult and they have to handle it. That's for the participants.
So, so here conciliator has nothing, because whatever party say is going to make them into an agenda and encourage them to start discussion.
Correct.
Okay, then the next is the actual conciliation process. So, now as a conciliator, he should identify the common interest between the parties and tell them that discussing, settling is important because you have so many things in common.
Correct.
Because conflicting interests are already listed in the form of an agenda.
Yeah. Correct.
And what has been ignored by the parties is the common interest.
Common interest. Correct.
Because if the work progresses,
yes,
employer earn profit, they earn wages. It's a common interest.
Yes. And community interest is protected, though it is not there in their focus.
Okay, yeah. So therefore, it's a job of the conciliator to list them out.
True.
And keep quoting them on the negotiation table so that they are encouraged to continue discussing.
Correct. How bad it is for each party to live with the dispute is to be said again and again.
Yeah.
The conciliator.
And then next is caucus. Now, I was going through the rules of the competition. We have not put any marks for the caucus.
It's not mandatory.
It's not mandatory.
It's not mandatory. Yeah.
If the conciliator decides things are going smoothly, I did not call for a caucus, don't call.
Yes.
And if he calls unnecessarily, judges will be there observing it.
Yes. Anyway, we are going to talk about it to the judges during briefing.
Briefing, yes.
And we'll alert them. See if a caucus is made justified use or otherwise.
Otherwise. So therefore, why caucus should be called? That clarity the conciliator should have, even negotiating parties should have. Now, sometimes what happens is the requesting party keeps on giving options.
Correct.
Now I'm talking from the competition point of view.
Yes.
Students will be having certain kind of misconceived notions that if I tell that we should settle the dispute on these terms,
correct,
you think that agreeing to those terms will give me marks. So I have to refuse.
Yes. Not necessarily.
Not necessarily. So that is that's the misconception they have. Because what judges are going to do is, before accepting my terms of settlement, you are evaluating them.
Correct.
What are interests that these terms are fulfilling? What are the interests these are not fulfilling? And therefore, these are the modification I'm suggesting. So that evaluation is very important. Before rejecting or before accepting.
Correct.
So that is something that they should work out during the conciliation process.
Agree.
So many times what happens, this is what I have seen, that the moment a team comes up with an option, generate a very innovative option, other party goes into gloomy mood. I'm losing, I'm going to lose this round. Because they came up with an innovative option. No.
Not necessarily.
Yeah, see, they might have taken 30 minutes of CI to innovate this option. you have lack of time, but you can very well evaluate it
Correct.
and decide over that.
Yeah, that
So-
is fine.
Yeah, so therefore,
Hmm.
caucus, not mandatory,
Yeah,
option generation,
Hmm.
innovation is welcome.
yes,
Look at the larger picture rather than scoring the points. That
yes,
itself.
yes.
Because judges are also more interested in understanding the overall impression of the party that has been created.
Correct, correct.
Overall
correct,
impression.
correct.
They don't decide the case on minute basis.
Yes. And also they may not be looking really at the settlement itself.
Itself.
How you
Conducted yourself.
That's
That's what plays a role.
Yes, true.
So I think we must appeal to the participants that keep a larger picture in mind when you sit for conciliation and negotiation.
Correct.
So-
That shows of their involvement, which impresses the judges.
Judges, yes.
True.
So then, again, anything more you want to add as far as the conciliation process is concerned?
That's fine.
Caucus
I
is
think we
fine,
have
yes.
covered. Yes, we have covered.
We have covered most of the
Yes,
things.
yes.
And now the next point is about the conciliator's ability to control the process.
Yes, yes.
And this is again another major difference. In mediation, the mediator is appointed by the parties and his fees is paid by the parties. So he is under certain level of obligation. But whereas conciliator is a representative of the state,
Yeah, that marks the distinction.
that is a major distinction in
Correct.
his behavior.
That's what I went to tell you a while ago. Correct.
He will be having more control over the process.
Should we use the word control?
Yeah.
What do we mean when we say control?
No, see, conciliator is a person who has responsibilities
Correct.
with no powers.
Yes, yes. And you have a responsibility not to agree, but to respect
Respect.
the presence. But to respect the presence.
You have absolutely no powers.
Correct.
Whatever powers they have mentioned in the act are only calling them
That's
as a
right.
witness, investigate, find
Yes.
out the truth and other things. But again, the idea is, even if you find out the truth, anyway, you're not going to decide the case.
Correct.
What is the use of finding?
That's why
Investigating and finding the
we
truth.
described him during our student days, the paperless tiger. Sorry, paper tiger, teethless tiger, paper tiger,
Toothless tiger, paper tiger,
and so on.
fifth wheel to a coach.
Correct. You're right.
Yeah.
Correct. Correct.
So those are the words we used to call
Yes.
conciliator.
Yes.
So now, when he is having the control over the process, he must ensure that he laid down the rules
Correct.
and everyone stick to the rules.
Correct.
And anybody who misses the rule.
Correct.
Again, in the meantime, there are two conciliators belonging to two different teams. Don't you think you are expecting too much? They are competing each other by collaborating with each other.
Expecting.
How do you expect?
Yeah,
them to do that?
expecting too much from the participation is the competition.
Yeah.
Is the competition.
Yeah.
Otherwise, it can't be called the competition.
Okay.
I don't want to delineate any more than this.
So therefore, the 30 minutes which requesting and responding parties are working on the CI, the conciliators should sit together
Yeah,
and allot the work for themselves.
correct. True. We will advise it. Correct.
So that they don't compete with each other
Yeah,
on the conciliation.
Though they are going to score individually
Individually.
and take their scores back to their team,
Yeah.
when they sit there, they should have this idea that judges would not be marking them if the compatibility is not brought between them.
Yes.
They must make sure to bring the compatibility.
Compatibility.
That's very important.
Teamwork should be seen.
Teamwork should be seen because they work as a team. Right. It's okay. There is one casualty. If they come in complete, what should I say, compatibility. I don't know if the judges are going to mark both of them equally.
Possible. But anyway, that doesn't make a difference because the requesting parties' marks are going to be added.
True.
And then only the team score will come.
Very true. Very true. Yeah.
So-
Let them not miss out on
Yes.
bringing compatibility.
I think if they don't bring, if one conciliator snubs the other fellow, doesn't allow the other person to
Yeah.
speak,
They would be
I
doing
think
injustice.
judges should be observing it and taking note of that.
Judges, such conciliators would be doing injustice to their teammates.
Teammates, yeah.
They would be. They would be. So
So-
conciliators have to be very careful.
Over dominance over the co-conciliator, or too much of submission to the co-conciliators, both are dangerous.
Yes. Bringing compatibility.
Yeah. Teamwork, that is what is expected.
True. The judges would be smart enough to identify these and score them accordingly.
Correct.
So,
Anyway.
so one query from the participant. When one of the negotiating parties propose an innovative solution, can conciliators support it? Will that be treated as bias?
It will be bias. Because what happens is we should give a freedom to the team, party, to evaluate without any external pressure. The moment a conciliator appreciates it,
No.
there is an invisible pressure put on the party to accept it. So he should maintain an impartial face and watch, because you give them a complete freedom to decide. And sometimes what happens is parties may request, what is your opinion? Who should withhold your opinion? You shouldn't give your opinion. Because parties are having an assistance of a counsel. They should rely on the opinion of the counsel rather than the opinion of the conciliator. Of course. Because that invisible pressure, it really plays.
Because in the conciliation process, we want to showcase that it is a settlement of the parties.
Yeah, yes.
Assisted settlement,
Assisted settlement.
not imposed settlement.
Yes, and if some party, the vulnerability, what we are talking about, counsel is there already to protect them. Conciliator can add to that counsel because it's his job.
True.
Fair and amicable settlement is his job.
Correct.
So that is, we were discussing about the role of conciliator in
Yes.
controlling the
Yes,
process.
we got that.
Counsel now. Now, it's a party-centric process. ADR is a party-centric process, unlike litigation, which is a counsel-centric process.
In terms of taking role, taking a front
Because
seat.
a party would be sitting in the corner of a court hall.
Yes.
Counsel would be the star performing in the middle of the court hall.
Yes. In that sense, yes.
Yeah.
Yes.
But here what happens is, party is the one who is going to agree for the settlement or disagree for the settlement.
So you mean let the counsel take the role of a friend than of the front seat?
Yes. Okay, he should not be taking front seat. He should be taking friend's seat.
Front seat. However long he speaks, however long he participates, it's not just the question of participation and duration, but the approach.
And second thing is, I think if you have gone through the assessment criteria, I think we have mentioned about legal knowledge.
Yeah.
Again, please understand one thing, conciliator is not sitting there to decide the case.
Yeah.
So quoting case laws, quoting the sections and other things is not going to cut any cake.
Correct.
So what is required here is your legal knowledge as to agreed terms, whether they are enforceable under the ID Act,
Correct.
whether they are enforceable under Contract Act.
Yes.
If at all it should be made into enforceability,
Correct.
what should be the terms, what should be the language used, precision, and then the demands made by the parties, whether they are tenable legally.
Yes. Yeah, very important. You might agree, but not tomorrow I can't enforce it.
And can't enforce it, yes.
Correct.
So therefore, and also most important thing is parties' demand. Now, as we said, ADR is win-win situation, achieving a win-win situation.
Yes.
But it's not a charity, but it's a necessity.
Of course.
Because you should not end up in the court.
Yeah, it's a necessity. Well said. It's not a charity. It's a necessity.
Necessity. If you have a win-lose agreement, the losing party definitely disrespect the terms of the contract.
Yeah.
And then you want to enforce the terms.
Litigation. Yes, you're right.
Why you went for conciliation? To avoid litigation.
Correct.
Where you are in litigation.
Landed in litigation. Yes.
That's why win-win must be ensured, and it's the counsel who has a major role to play.
And his legal knowledge will help him do that.
Do that, yes.
So should we stop at that, or should we also talk about the lawyer counsel suggesting and barring unethical settlement? Not illegal, but unethical. Should we deliberate it or not? Yes.
Unethical thing, yes, definitely.
I think it is couched under what we spoke about fair and amicable.
Fair and amicable includes
Yeah.
not only illegal,
Yeah.
it includes unethical also.
Yes.
So there's a conciliator to look into it. Because again, when you say counsel, his duty is not only towards his party, his duty is towards the community also.
Yeah, true.
Because my teacher used to say that society has given you a monopoly to practice. Nobody can stand up and argue the case in the court other than the advocate. And who gave you that power? It's the society.
Right.
So you have to give back to the society. So ethics, again, is the necessity that you need to follow it so that the society is benefited with your.
It may not be a parameter.
Yeah.
Our participants, it may not be a parameter
Yes.
for judging. So let me clear that.
Yeah.
But you have to be cautious about that. But that because that creates an impression
Yes.
in the mind of the judge for you tomorrow.
Correct. Correct. Because you are going beyond the call of the duty.
Correct.
And protecting the interest.
You're right.
So the counsel is done, I think fairly done. If any questions are there, they can raise it so that to be able to cover that. Now coming to the clients. So when you look into the clients, now this man or woman is a layman, okay, sitting in a room where there are lawyers are there, government officers are there. So they should understand the magnitude of the situation.
Yeah. Let's say non-expert because he's not trade union leader too.
Yeah,
Why do we call him layman? Yeah.
And there may be an employer, but his legal knowledge and other things will be bare minimum.
And when they are parties to the dispute, their minds are put off to several things.
So party, the client needs to play to provide a role play. So if I am taking the case into consideration, if I am a CEO of a company, I should play the role of a CEO.
True. It's a role play.
If I am a member of working class, the champions, I should play their role.
Correct. It's role play.
And for playing that role, you should understand them in and out.
Getting into their shoes.
Yes. Once I was coaching a team where the party were fishermen.
Okay.
Other side is the trawler owners.
Okay.
These were the fishermen.
Okay.
I asked my team to check their life, how they lead their life.
Correct.
And they really did hard work and found out. And they found out what time they wake up.
Okay.
What is their rituals, morning rituals, and how hard work they do. And what are the nature of diseases they face because of continuous exposure to sun. Because when they are on the water, on the sea water, when there is direct sunlight falling on them, there is no shade. They are completely on the sun. And then the sunlight is getting reflected by the water also.
Yes.
So there is a double heat they go through. So all that they studied. And when the client was presenting the life of a fisherman, judges were so appreciating. And they said that we never knew that the fishermen go through all these things. What you are demanding is very, very valid.
Oh my God. So more than the skills, good role play helped them.
Yes. Good homework helped them.
Correct.
So that's something that you need to work on.
Reality. It's close to reality.
Close to it. And I don't, this again, my suggestion, that don't bring down the computation to the bookish level. Like fact sheet is silent. Why you call it as a fact sheet?
Yeah.
You say, I'm not aware about it.
Correct.
When you're doing a role play, you don't talk about fact sheet. Talk about your role.
Yes.
You can always say that if you want to know about it, give me some time. I will inquire and let you know.
In and out.
So that's what is expected from them, and they have to involve themselves in the role play.
Yes, and we also covered and said as an approach, it is client-led.
Yes.
It is client-led process assisted by his friend.
Yes.
And next is conciliator.
So now coming to the final part. This is again the uniqueness of the event designed by you all.
Yes.
I will not take credit for that. If it is successful, you may consider me.
I gave the credit already to Jai, who has done so much homework in this regard.
Now, from semi-final onwards, we are presuming that semi-final and final is a conciliation of a 14th day.
Yeah, it is. Yeah, last day.
Last day.
Correct.
After that, conciliator has to draft either of the two.
Yes.
Settlement.
Yes.
Or failure.
Correct. Because the state is not interested in letting you continue your conciliation process indefinitely. We have sent you, do your job. Please promote settlement. Else, tell us why you tell us why you did not. Give us the failure report. We'll take next action. Is the reason.
Okay. Yeah. So, just correct me. On prelim 1, prelim 2, quarterfinals, it is the conciliation going on within the 14 days.
Yes. Yes.
Semi-final and final is the 14th day.
Because we want them to write
the settlement.
Yeah, in our problem sheet, we call them annexer C and D.
Okay, now let us come to the drafting of that.
Yes.
Again, for the benefit of the participants, because this whole session is empowering them.
Correct.
So that the quality of computation will elevate itself to the next level.
Yes. It's not because the regarding the rules orientation has happened already.
Yeah.
This is something different.
This is very conceptual understanding of it. Now let us start with the failure report. Okay. Now, on the day of the negotiation, they negotiate. They are doing very well. But they ran out of time. I'm not saying they failed. They ran out of time. They are willing to settle. But time is not.
Yes.
Now, how do you expect me as a conciliator to write a failure report? It's a failure. It's incomplete answer. You imagine yourself writing an answer in the exam.
And now you have to imagine if the bell goes, what the invigilator will do, the conciliator will do that.
And remember one thing, parties are under no pressure to settle. Again, this is one thing which every participant should note down. There is no additional marks for settling the dispute.
Yeah, not at all.
There is no negative marking for not settling.
Yeah, not at all. A very well written failure report may score better than the settlement.
So therefore, negotiating parties are not in a hurry to settle this. Even in the semis and in the finals.
True. Yeah.
Now the whole burden is on the conciliator to draft.
Yes.
Okay. Now when you go through the draft, I think let me go through the assessment criteria.
Okay.
Yeah, it's in me.
You want the score sheet?
Score sheet. Now, first they are looking into the structure of the failure report.
Yes.
Approaches taken and efforts taken by the parties. Okay. Now, what is the purpose of the failure report?
Yeah, I think by now participants must be aware, and in fact, I did cover it in my previous interaction. That is, as I told you, I have sent you the conciliation officer to mediate between the parties. Whether they like or not, you should go and mediate because you now know that industrial dispute exists.
Okay.
In fact, law says even if industrial dispute apprehended,
Yeah.
you can
About to
intervene.
come up.
Yes, you can intervene and start your proceedings. You call them. Look, I am seeing you dispute between you. I am here to help you. Come settle. If the 14 days time or 2 months time, as the case may be between conciliation officer and board of conciliation, if the time is over, state, as I told already, is interested in settling settling quickly, so that it brings back industrial production starts. That's the purpose. That's first purpose. Second thing is your failure report will serve the purpose of investigation of facts of the case. In the course of conciliating, you have a duty to investigate the facts and surrounding material. That report will come to me, the state, and you will write therein what happened. Why did the settlement fail? You will be writing. So that will give an indication to the state government, what we call appropriate government, as to how the state should proceed with. Should they simply go with compulsory adjudication? Should they give little more time for parties to go back to collective bargaining? Or should they allow them to utilize another method that exists under Industrial Disputes Act for resolution of the dispute?
Okay, now let us see.
Yeah, let me complete that. Another method I'm talking about, arbitration.
Arbitration.
This is the purpose. Yeah. When through the report you sent to me, if I see no ray of hope, I will be taking a call that I will refer it to adjudication.
Okay, keeping the situation which I narrated, we ran out of time. Parties are behaving very well.
Very difficult. That is very difficult question.
So that means the failure report must say, if time was provided to me, I would have settled it.
Correct.
It's a fit case for further attempt for settlement.
True.
So that means appropriate government will send it for board of conciliation.
Board of conciliation. Exactly.
If my report says that I tried my best, but one of the parties is behaving unreasonably, the demands and other things are, is changing the demands now and again. So
consistently unready for settlement.
So the state will refer it to labor court.
Labor court. Adjudication. That's a good idea.
This failure report has a lot of value.
Indeed.
So the one of the content of scoring criteria is approach of the taken by the parties.
Correct.
So he should be very elaborate in that.
He should be.
Both the parties, how the requesting party behaved, how the responding party behaved. And also he has to give his conclusion about each party.
Yes, he has to. And that is going to be the torchbearer for the state government. The failure report is just so-called. It's not failure report.
Yes.
It's going to be the torchbearer for the government as to what is to be done next with the industrial dispute. Yes. In that sense, failure report, yes, has a great value.
Great. Then recommendations. Down next is the term recommendations.
Yes.
So recommendations would be the next course of action.
Yes.
It's a mere form of a suggestion.
Yes.
And not binding on the government. Government may agree to
not you. Because we know the story under section 10.
Yeah.
So much of discretion to the appropriate government to refer, not to refer, whom to refer. And as you rightly said a while ago, failure report contains the chances still exist. It's a case for going for board of conciliation before they resort to adjudication.
So
who knows it's possible? Sorry, who knows it's possible? If the parties have said we will not, we may not settle before you, but we would like to go for appointing a person who will decide for us, like arbitration. There's a possibility. There's a possibility. Then the state may keep quiet for some time and see if the arbitration chance parties are looking at, because they have expressed it so, and conciliation officer reports it so. Possible. Thus, failure report has significance. Participants who are writing failure reports have not done a bad job.
Yeah.
Great.
Now coming to, I think you made a very valid point. So if you are writing a failure report, that means you have done your job exceedingly well. Yeah? Because you are actually it's a misnomer. Failure report is a misnomer. It's actually the next course of
Literal
action.
sense, in literal sense.
Literal sense, it's wrong.
It's not.
So let's come to the next one. Memorandum of settlement.
Yeah.
And if you go by that memorandum of settlement, that analysis of approach taken by the parties. Now, when the matter is already settled,
Yes. Yes.
this should become a prelude to the settlement.
Correct. Correct. Correct.
So, you correct me if I am wrong. I will start the settlement drafting by writing about how the parties behaved and what are the causes
Correct.
which led to the settlement,
Correct.
and appreciate the parties who have done exceedingly well in coming out with the settlement.
Yes.
But this is a pure opinion of the conciliator,
Yes.
no bearing upon the judging.
Correct. Correct. Correct.
Then you would start drafting the settlement agreement.
Correct. Correct. Correct.
Correct. Okay. Now, when you draft the settlement agreement, what are the things that they should keep in mind?
Drafting the settlement or analyzing the whole process?
Drafting the settlement.
Okay, you come straight to drafting the settlement. I think as we spoke a while ago, terms as agreed between the parties. With precise language, without scope for much ambiguity, is the first thing. That means drafting skills.
Drafting of
Agreed terms.
Agreed. Drafting of contract.
Drafting of contract. Yeah, because settlement is a contract.
Contract.
Yes. Looking at the law to check enforceable nature of the terms. And what else could be?
Yeah, so that means first things that we would be looking at it as an organizer.
Correct.
Is practicability of the terms and conditions, enforceability.
Enforceability, because once you settled it, your counsel must have advised you don't settle for it. It's not practical.
The most important is whether those are the valid terms under the Indian contract.
Yeah, that has to be looked at, because it becomes unenforceable contract. There's no point.
So, like agreeing to agree something in the next meeting, it's vague.
Vague.
And vague terms cannot be enforced.
Not at all. Yes. Futile. Exercise becomes futile.
So, in case of a dispute, we will decide after conducting a meeting what is to be done.
Correct.
Unenforced.
Correct. True.
Because there is no decision taken.
Exactly. For uncertainty, agreement fails. Agreement doesn't mature into contract at all.
Yeah.
Yes, you're right.
So, therefore, the language of the terms becomes
true. You are coming back to the one we started. Why analysis of the process? We started with why analysis of the process. I was, interested in responding to that.
Yeah, we'll come back to the first part.
Yes.
First part of the memorandum.
First part where you analyze.
Yeah.
What's the if the settled terms are drafted well as per the expectations that we expressed, what purpose this would serve?
This would serve.
Why we are asking people to analyze it?
Yeah.
If failure, you may analyze. When success instead of settlement, why do you analyze?
Analyze. Yeah.
We have thoughtfully done it for the reason. Look, it's in the knowledge of all of us. When it comes to interpretation of statute, you just don't refer to the whole statute alone. While preamble has been considered as part of the statute, you refer to preamble, of course. But you do refer to things beyond statute.
Correct.
Maybe parliamentary history, constitutional assembly debates, at least the very immediate material statement of objects and reasons.
Correct. Yeah.
Isn't it?
Yeah. Preamble.
And if you come to government orders, if you have seen when gazette comes before Adesha, before order, what was the circumstance under which this came to be discussed, how agreement, disagreement happened, how the authorities have come to this conclusion, that prelude is given. Thereafter, the order follows. So, be it the statutory provisions, be it the order of the government, there is some background.
Yeah.
In the backdrop of this, the terms are going to be interpreted. I believe the expectations that we expressed, especially drafting expectations, since language suffers from diseases.
Yes.
If accurate drafting did not come, if there is any lacunae, if there is any scope for interpretation, double meaning is possible or multiple meaning is possible, you could resolve it well with the paragraphs of the analysis that you did. That is the purpose with which we want parties to give analysis of the whole process before they step down to draft.
On a lighter side, when you said double meaning.
Come on, I knew I will get caught. That's why I also used multiple
We
meaning.
belong to the era of Govinda
Yeah.
in Bollywood
Yes.
and Kashinath
Yeah.
in Kollywood.
I know very well.
The double meaning has its own meaning. That's why you corrected yourself, multiple
Yeah, because I did not mean that meaning. Yeah, yeah. This semanticism often catches us.
Yes. Okay, with this, I think we have come to the end of it. Thank you very much.
So there are a couple of questions.
Oh, okay,
Yeah,
I
yeah.
can take them before we wind.
There are two questions. One question is related to the role of counsel and another one is to the role of client. The first question related to the role of counsel is the counsel restricted to giving advice to the client and in no way can take lead role during the conciliation process?
See, according to me, counsel is a friend sitting in the negotiation table along with the client. So his role is not only to assist the client, but his role is to play a proactive role in the negotiation process. He can talk to the other party, he can appeal to the other party, he can involve conciliator if he finds the other party is not playing fair. He can say that, sir, Mr. Conciliator, you laid down the rule in the beginning and they are breaking the rule and you're not taking action. Please look into the matter. Because he is an expert sitting in the room to assist a layman. So he has a role. But while speaking about the role, client plays a major role compared to.
Yes.
So I should say 55 is the role of the client. And what is the remaining amount?
I would rather say, Professor Patil, I would rather say, as we also spoke about it a while ago, in light of that the question has come, I'm very sure. That good that the question has come. See, it's not that in the course of our talk we said, the counsel shall take a backseat. He shall take the approach of a friend. He might end up speaking more than the client. If it is so, it's not wrong.
Not.
In approach, not in terms of the time both of you spend, not in terms of the domination one will have over the other. In terms of approach, it may so happen client speaks less, counsel speaks more. That is not bad per se.
Yes.
That is not bad per se. If a friendly advice is more required, you could do that. Hope that answers participants. In approach, you have the role of the friend, and it does not mean to say that counsel shall spend less time or not dominate or use more time, leave it to the client. No, we did not mean that. I repeat, in terms of approach, you play the role of a friend.
Right. But as far as talk time is concerned, it can be equal to the client or more than the client.
Purpose is, are you playing the role of a friend?
Yeah.
Or you are telling your client, come on, I'm deciding for you, you keep that.
Yeah, that's not the
approach. Yes. That's not the approach. You must have taken more time, but you are playing the role of a friend to your client.
So, second question, sir. This is regarding the role of the client. What would judges look for in the role of the client in the whole process?
So judges would be mainly looking into your role play, how well you have, and the most important thing is the role play is only one part of it. The remaining whole thing is how well you have innovatively raised an option through which a settlement can be achieved. And if the other party raises an option, how well you evaluate the option and respond to that. So, and how well you use the conciliator in your process of the conciliation. Because conciliator is sitting there, as Mallikarjun said, that I am here to help you. So that means my duty is to take his help. So how well you take his help during the conciliation process. So all that plays a role because it's a holistic understanding of the thing. Now, if you look at the score sheet, so now let me take the score sheet of the client. So clarity of the objectives, engagement with the process. That's what I was mentioning about. That how well you evaluate the options generated, understanding the legal and practical realities. So that means he has to take the advice from the counsel to understand the legal realities and the practical realities he has to understand. And based on that, client should look into the settlement, possible settlement that can be achieved. And communication, responsiveness. Responsiveness also includes how well you respond to the other parties' needs, requirements, and innovations done by the other party. Professionalism and conduct is always there. Again, please remember, in your role play, one thing they should not forget is the situation in which they are conciliating. See, there is a dispute. There's a loss of jobs, termination,
Yes.
strike.
Families on the street.
Families are on the. When so many things are going around you, how can you smile at one another, shake hands, and talk nicely? That becomes an artificial behavior on a conciliation table. So that's what the role play is all about.
Becomes necessary for the client.
Client. As a CEO, he should be looking into the kind of turmoil his company is in. So all those things has to be taken.
Correct. Now that we expressed the role that is to be played by these three parties, conciliator, counsel, and the client. Conceptually, we have figured out role for all three of them.
Yes.
Now, if we may have a look at the rules of the game of this competition, since the participants know, it's not teams that are assessed, it is individuals that are assessed. And individual score become important for teams forwarding to the next round, becomes important for other three awards that are awarded, like
best conciliator, best client, best counsel.
Yeah. And also for team. That's why, in addition to whatever we have said, it is a good approach for all the teams to figure out quite good role for each of them, so that the judges get an opportunity to give them scores.
So should I say that a cooperation can fetch you more marks than competition?
Yeah, obviously yes. Obviously yes.
Cooperation.
Yes. Cooperation in allowing each one to exhibit their skills in addition to the purpose. Because anyway, we are working on hypothetical problem here.
And again, participants, we want to tell you, we are sharing this, we have shared this with judges. And if judges are busy, we are sharing the YouTube, because it will be hosted on the YouTube. We're going to share that URL with the judges so that they can find a time and watch and understand that how organizers looked at this event and how the participants have been told about this event
and accordingly set their expectations from the
judgment.
Correct.
So there is one last question. So this is regarding the role of conciliator. Sir, how authoritative can the conciliator be? Can he make rhetorical statements, pose questions to understand the parties better?
Last thing he can do. First two, he should not. Because he cannot be authoritative. He should not be authoritative. But at the same time, you also have to score. You also have to intervene. It is conciliation competition. And you cannot exhibit authority. That's where we spoke about conciliator's position.
Have responsibility but no powers.
Yes.
Now see, imagine you are authoritative and one team says, I want to go out.
Yeah.
I don't want to talk. I don't want to negotiate.
Correct.
Then what is your role? What you are going to do?
You know, Patil, when we were discussing about why conciliation failed in India, in resolving disputes, why we are going to the last stage of compulsory adjudication. we were trying and understanding, in addition to calling him a paper tiger, we were understanding what was that? Conciliation officer and the qualifications for conciliation officer. We were thinking he should not be technically sound, he should be a psychologist, you know, on a lighter tone to drive the point home. We were saying he should be thick-skinned.
Yeah.
You should not be authoritative, you should rather be begging them.
Yeah.
It's in your good interest, I have come to help you. Please sit, please sit. That should be your approach and not authoritative.
I think authoritative role goes well with arbitrator
Yeah,
rather than the conciliator.
yeah. An adjudicator after all,
He
he is
is an adjudicator, so he can send them out of the room to
Arbitrator.
decide the case.
arbitrator,
Arbitrator.
not the conciliator.
Arbitrator, yeah. So therefore, conciliator can control the process, but at the same time, he cannot be authoritative outright.
Yes.
A lot of balancing has to be done by.
Has to be.
Shall we wind up?
Yes, sir.
Yes.
That's it.
Thank
So
you.
thank you very much. It has been a long process. I don't know how long we took.
Yeah, I think we went more than 1 hour, I believe.
1 hour 15 minutes.
Oh,
1 hour 15 minutes. That's quite fast.
Hope that would be useful. Yeah, hope that would be useful.
Yeah. All right. Thank you very much, and all the best. May the best team win.
All the best, all the best, all of you. Thank you.
Man, great work.